statistics.
My Lords, I'm expecting us to go through the statistics for about 10 minutes. Can I make one factual correction before we come to that?
Yeah.
Which is the email of October 22, which resulted in putting Miss Begum onto the transfer list. I may have misunderstood, but it sounded to me during the morning that it might be thought that that was because she was pregnant at the time. She wasn't. The baby, she was subsequently pregnant. The baby was born in September 23, 11 months later. So it was not in anticipation of a second child. Yeah. It was because Tower Hamlets were considering it was either overcrowded or potentially overcrowded.
Or potentially unsuitable, yeah.
Yes, but in any event, they acted as though they thought it was unsuitable at the time.
Well, that's not for you, actually.
And it's not for me. It's not for me. No, I just wanted to make it clear she wasn't pregnant in October.
Yes. You can genuinely help us on.
My Lords, on the statistics, if it's helpful to have page 43, the appellant statistic.
43 in the skeleton.
Sorry, in page 43 in the core bundle, which is page 47, paragraph 47 in the appellant skeleton, and then pages 88 and 89 in the core bundle, which are our shelter's analysis of the statistics.
Yes.
And shelter took our analysis from the appellant statistics, although those sitting behind me did go back as far as they can and check them against the primary sources that are in the bundle. So we were, having done that, we were happy to adopt them. So the first point, my Lords, is the point I referred to on my feet this morning before we broke for lunch, which is that the pool that we take first is the pool of people in what's being referred to as temporary accommodation, what is Part 7 accommodation provided by Tower Hamlets. And there is no doubt that households that contain women form a significant proportion of that accommodation as against households that contain men. And that is our figure 2 at the top of page 89, where on the left-hand side, the pool of those in Part 7 accommodation, 74% of those households, I'm leaving out the decimal points, contain at least one woman. 25% only contain adult man. Possibly men, but unlikely. And I've made the point that there were 2 reasons for that. They're in Miss Pennington's witness statement. One is that women and lone mothers in particular have a higher experience of poverty and so forth. They're therefore more likely to need homelessness assistance. And the second is that once they do apply as homeless, they're more likely to be owed an accommodation duty because if they have dependent children, they will be in priority need. We then focus on 2 points. The first is the increase in proportion of households containing at least one woman. When you look at the second pool, which is, the second pool is households who are in accommodation that is agreed to be unsuitable. And that is the 5th column in the appellant skeleton, where it says info 1 unsuitable. Or indeed it could be the 7th, the last column, info 2 unsuitable. And it's quite graphically shown in the pie charts, the proportion of people of households that contain at least one woman in that second pool jumps.
What is the figure?
90%.
So from 74 to 90%.
Just over 90%. It's 91.2% if you take info 1, and it's 92.8% if you take info 2. I'm content to say just over 90%. So it jumps from very slightly under 75% to just over 90%. and the proportion of households that only have an adult man decreases from 25% in the first pool to 7.2% in the second pool.
So you give those figures from 25% to
7.2% in the second pool.
I mean, this is really because single people are being knocked out, isn't it?
Well, yes.
Lone people.
Absolutely, and what is very clear from the appellant's analysis is that the problem that Tower Hamlets have, and Shelter are of course sympathetic to that problem, is finding suitable accommodation for families with children. Because if one was only comparing the families with children, then we would be in a different ballgame.
And if I'm right, then if you go back to the table in the skeleton argument,
Page 43.
43,
Yeah.
if you exclude the figures for lone females and males, then you can't discern any difference at all in the treatment of men and women.
So that brings me on to my next point.
But is that right?
Well, let me just, I will come back to that if my Lord will give me a minute. I want to make one additional point on the statistics and then I will answer that. Which is, while we're still on the pie charts at 88 to 89, if my Lords look at the bottom of page 88, footnote 4, a similar exercise was carried out in terms of the households that contain at least one man. And so they are the single fathers, the single men, and then, of course, roughly half, for the purposes of today, half the two adult households.
Yeah.
And
sorry, that footnote there. What does that, I mean, you've shown us two pie charts on 89. Is this footnote? What is this footnote referring to now?
so the footnote is a footnote. If my Lord looks up to B towards the top of the page,
Yes, it's that is there. Yes. So what,
B is what produces, the analysis in B is then contained in pictorial form in figure 2.
so if I look at the pie charts on 89 now, because I don't want like not to be compared with like.
Yes.
You show me big black areas, which
Yes.
you tell me are 74 and 91.2.
Yes. And that's
Are the grey areas the men then? 25
grey
to
areas are households
7.2.
that only contain men.
Right. So that's the comparative. Okay, that's just the
And
other
we
half
say
of the
that's
pie
what the
chart.
comparative is. And then in footnote 4, we've done a similar exercise, but we haven't illustrated it with a pie chart. But there's the same exercise if you take all households that contain at least one man. That's lone. I've just said it, haven't I? Then they are 42% of pool 1. Those in part 7 accommodation.
So pool 1, part 7, they're 42%, but pool 7 agreed and suitable.
Then there is a very small increase up to 45.6% under the Info 1 figures, and indeed under the Info 2 figures. Your Lordships will know that's when the change in the database was in August 23. Under the Info 2 figures, there's a slight reduction.
And the reason for this is that single men with children only originally accounted for 3.6%, whereas lone males accounted for 11.2%, which is a much higher percentage.
Yes. And
Once you knock out most lone people, then inevitably you find that the proportion of men doesn't go up as much. I mean, what you're sort of reflecting is the fact that lone males account for a much higher proportion of the original total than single males with children.
yes, and what is overall being reflected is the point I made earlier, that the Tower Hamlets' difficulty is finding suitable accommodation for families with children. It's much easier for them to find it for those without children. That's clear. That is a social context.
Yeah.
My Lords will all be aware of the words of Lord Justice Lewison that one would have to be a hermit not to know that there is a housing crisis.
Especially in London.
Especially in London, and if anybody knows it, Shelter knows it.
Yes.
So clearly that's the social context. But there are two reasons why it's wrong to knock out the individuals who don't have children. And the first reason is Section 19 of the Equality Act, which is page 100 in the authorities bundle, tab 6. And it's subsection 2A. A applies or would apply the PCP to persons with whom B does not share the characteristic. So B has the relevant protected characteristic, which is accepted as being a woman, that of being a woman. Leaving aside arguments about transgender, let's leave that aside. For the purposes of now, there is only one type of person that can be compared with being a woman, and that is a man. And so therefore, this case has been pleaded, and the respondent hasn't taken a point against it, that the indirect discrimination is against women as a whole.
Well, it's both, I understood.
Not parents, sorry.
I thought they said both.
Well, they've said lone mothers, but within their protected characteristic is women.
Yes, I understand that, but I thought their case was it was lone women with children and women generally.
They're explaining that there is a particular effect on lone women. I will leave that to them.
Yeah.
But the protected characteristic being put forward is that of women, so the comparison must be with men. It's not single mothers as against single fathers. It's not single mothers as against two-parent households. And therefore, it must be right that the statistic on which our pie charts are based is of the whole of all of the various of the people in the appellant's charts, including those without children. For the purposes of Section 19, that must be right. And we say that's very clear. The second reason why that's right relates to, is on the basis of Baroness Hale's speech in ESOP, which my learned friend has already taken you to, but if I can just highlight a couple of points. It's page 360 in the authorities bundle, tab 16. So the first point to highlight is at paragraph 24. The first salient feature is that in none of the various definitions of indirect discrimination is there any express requirement for an explanation of the reasons why a particular PCP puts one group at a disadvantage than compared with others. Now, we are talking about why, and we're talking about why in terms of the housing crisis, lack of suitable accommodation for families and so forth. But why is not the issue as regards establishing not only whether there was a PCP, but whether that PCP ended up in a particular disadvantage to women. Getting there, why is not relevant. Why might be relevant when it comes to justification, and it's only once justification has been considered that the court can say whether or not there is indirect discrimination. I'm aware of the time, yes.
We've had this morning, to be honest.
Sorry?
We've had this morning.
Yes, well, let me just make the second point, which is paragraph 26, which is the same point. A third salient feature is that the reasons why one group might find it harder to comply with the PCP than others are many and various. They were called context factors. So we've been talking about the context factors. But we say that whilst it's important to understand the context, that is not part of the Section 19 analysis until you get to justification, when conceivably it could be. So that's the second reason why the first pool, those in Part 7 accommodation, has to be all applicants in accommodation and not just those with children. May I just turn my back and check there's any more points to make? My Lords, those are my points on the statistics and ESOP. I can say what I have to say in 2 minutes.
Can I just ask one question about statistics?
Yes.
Because I think you might have answered my Lord's question about paragraph 47.
I hoped I'd had, but I'm happy to keep trying.
Can I just, and it's my lack of understanding of maths, which is the problem here. When you worked out percentages,
Yes.
it seems to me instinctively wrong just to add up the percentages of all the different categories. And say add 2.7 to 37.7 and so on. Because in some instances, for example, low males, info 1 and 2, the numbers are so small that just to take a global figure of adding up all the percentages would fail to reflect the fact that people within the total pool would make a very different figure.
Well,
I want to know whether your jump figures and so on are done on raw data or are done on just adding up the percentages for the different groups. Have I been clear?
Yeah, no,
Yeah.
And actually my Lord's reminded me that I need to come back to a point my Lord made earlier this morning, so thank you. That's absolutely clear. It is right, of course, that, yes, the statistics are, once one gets down to lone females and males, they are small numbers.
Yeah.
What I can say is
It says that once one gets to the info 1
info
onwards
is
columns,
small
they're
numbers.
small numbers.
Yes.
The total numbers in TA, presumably quite large numbers. Well,
Yes.
they must be if it's 12.5% lone females out of.
Yes, we think
a
they're
lot.
thousands.
Yes.
Yes, overall, and so the 100% will be in the thousands, and then one can.
So is your footnote 4 in your figures based on adding up the percentages or adding up the raw data and recalculating the percentages?
They were certainly certainly the former. We did add up the percentages,
Right, so you've
but
added
I am told that was then checked against the raw data. I confess I didn't do that.
Right. Well,
But
check
the-
against the raw data is a set of words that's very interesting.
Yes.
I don't know what it means, you see. So all we know is you've added up the percentages at the moment.
We took that figure. We then went to the raw data and did the same exercise.
Right.
That's my
So
very
your
clear instruction.
So your
Yes.
footnote
Yes,
4...
my Lord will see nodding behind
Your
me.
footnote 4 doesn't help. Your footnote 4, then on whatever page it was it adding up the figures or was it adding up the raw data?
It was. It was both. It was first adding up the percentages. Secondly, it was doing that in relation to the raw data.
So it
that
was the
available.
same figure, remarkably, 42.2%, whether I just added up the figures or added up the raw numbers.
Yes.
Right.
And just so I understand, and I think this is what you're saying, if looking at the table at paragraph 47, if we take the columns from info 1 onwards to the right, you couldn't discern any differential treatment between men and women or any adverse differential treatment. Your point is that there is a jump from the total in TA column to the totals in the databases.
Yes.
And that fundamentally is down to the impact of losing most lone people.
Losing
Most lone people.
most lone people. Yes.
What
and
you
I-
conclude from that is another matter.
And
That's
I'm
what's
very
going
grateful
on.
because it allows me to make my last point on that, which is, and Baroness Hale makes this very clear in ESOP, it's not about outcome. And it's also not about direct discrimination. Nobody is suggesting that Tower Hamlets are deliberately treating women than men, anything like that. It is about whether there is a level playing field. And those are the words that Baroness Hale uses in ESOP. And insofar as there was already not a level playing field for everybody in Part 7 accommodation, then the difference is greater once one gets into unsuitable accommodation. So it's the difference, and my lords now have that is my point, I think. Can I just say, Shelter has put in a lengthy witness statement by one of our researchers, Miss Pennington, and for the purposes of the Court of Appeal, 4 reports. There were far more reports before the Administrative Court. I'm instructed to say that if my lords want any of them, they can be provided. But what the witness statement and the report show in graphic detail is the bleak conditions that there can be in temporary accommodation. Part 7 accommodation. When I say temporary, I mean part 7.
You mean part 7?
Yes. Temporary is a dreadful word. And
that's why it should be avoided at all costs.
We all slip into it, and I try and avoid it. Part 7 accommodation, that those standards can be very low indeed. The witness statement does not, on the whole, distinguish between suitable and unsuitable accommodation. So broadly, those bleak standards apply throughout the country in terms of Part 7 accommodation being provided. And the point is made by Ms Pennington that that has significant health impacts on mothers, particularly no mothers, pregnant mothers, and of course babies and children growing up in such temporary accommodation. And I know my lords will be aware of it, that is the social and national context around the temporary accommodation and the housing crisis. And I will end by this. There was some discussion in the morning about whether, if my lords come to the view that the wrong PCP has been identified, then it should be remitted back. Shelter doesn't oppose that, and we would also acknowledge that if my lords come to the view that Tower Hamlets have not as yet justified what my lords decide is the PCP, but should be given an opportunity to do so, then it's appropriate to remit it back. We don't oppose any of that. And our concern as Shelter is that, given the evidence that Shelter has put before this court and the court below as to the dire conditions in temporary accommodation, if local authorities are, if those dire conditions are being replicated in the form of local authorities breaching their statutory duty under Part 7, Shelter is extremely concerned about that. And if, in addition to that, the breach of the statutory duty leads to discrimination against women, then Shelter is even more concerned, and that is why we're here.
Can I just ask one further question?
Yes.
So, as we've analysed it, the differential on which you rely arises between the global pool and those who go into the database.
Those who are agreed to be in unsuitable accommodation, that's evidenced by them being on the database.
But the unsuitable accommodation bit actually is completely in line with the figures for the database. There's no difference between them.
In the appellant's check, I mean, if one just took the data, because the database consisted of different categories,
yes,
then if one just took the database, that would be confusing. But what the appellant has so helpfully done in the table is pulled out the numbers on the database who are there because it's agreed that they're in unsuitable accommodation.
I see that, but the proportions, as far as I can see,
yes,
the proportions in all the columns except the jump from total and TA to info 1 stay essentially the same. So if there is discrimination, it arises as you go from the overall pool to those people on the database.
To those people who are on the database because they are in unsuitable accommodation.
And fundamentally, as a matter of arithmetic, that differential is going to arise because you're knocking out most lone people. Now, supposing there were discrimination and supposing it couldn't be justified or wasn't justified, how could you eliminate the discrimination?
The Tower Hamlets would have to show, and we would say that this would be relevant to attempts to justify, which they haven't yet done, but Tower Hamlets would have to show the searches that they make for more units of family-sized suitable accommodation, and generally up their game. Sorry, that's very colloquial. That's far too colloquial. But generally, be taking every effort to source as much suitable accommodation as they possibly can. Shelter acknowledges that is very difficult indeed. But the duty to secure suitable, they should be doing that anyway, because the duty to secure suitable accommodation is immediate, non-deferrable and unqualified. So they need to be doing everything in their power to be sourcing as many additional units as they possibly can, helping us many applicants into long-term accommodation that is suitable, so they are no longer in Part 7 by using both their own waiting list and the private rented sector, doing whatever, lobbying the government to whatever extent they can in terms of more resources for the housing crisis and so forth. So it is a political response with a big and a small p from Tower Hamlets. We accept that, but that is indeed what Shelter would be saying that Tower Hamlets should do. And if my lords, in my lord's reading, end up looking at the end of Shelter's research report, Still Living in Limbo, they provide a number of recommendations that what both national and local government should be doing. Unless there's anything else I can help you with.
No, thank you very much, Ms Davis. Mr Atledge.
Thank you, my lord. My lord, excuse me, on that last point, Tower Hamlets would say that the purpose of the database is not merely to put on and keep on the radar those cases of greatest need and to put themselves in the best position possible to make a fitting placement as and when accommodation becomes available, but also as a means of driving procurement and to alert itself to where the deficiency in housing is most acute. And linked to that, my friend referred the court to the Shelter report that goes in with Miss Pennington's witness statement, Still Living in Limbo. Can I invite the court just please turn quickly to page 284 of the supplementary bundle. Where this puts in very clear and stark terms the underlying problem of this case. And that is that this is a 2023 report. It says last autumn councils warned that temporary accommodation.
Page 284 of the supplementary bundle?
248.
Or 248.
Sorry, 284. 284 of the supplementary bundle.
Yes. Oh, yes, I've got it. What is this document?
This is a Shelter document. It's a 2023 report entitled Still Living in Limbo. And it's placed before the court very helpfully to explain the difficulties that my friend has referred to. And it makes the point that last autumn councils warned that under 79% that temporary accommodation is at crisis point. A tidal wave of homelessness meant 79% of councils did not have sufficient temporary accommodation to meet current need. And that's the reality with which officers at Tower Hamlets Council have to grapple on a daily basis. And it was against that background that they have developed this tool which enables them to filter needs quickly and identify efficiently the best fit for accommodation that is or is about to become available, to ensure firstly that they can reduce it to a pool, a small pool of applicants who tick all the boxes going along the database. At which point, the evidence shows, it then goes for an evaluation. The case files, which are electronic, are then considered, and an officer decision is taken as to which of those applicants is best fit. This is emphatically not a waiting list, and it's fundamental to our case that this is distinguishable from the planned move list in the Birmingham case, which my Lord Justice Lewis will be very familiar, and also the background to the Birmingham case, the Airways case, and the whole development. So we say that this is the antithesis of the planned move list. It's not to park people, it's to try to keep them on the radar and to make placements in the best possible fit as quickly as possible so that they get out of their unsuitable into suitable. Also, so that properties aren't held void with a loss of revenue to the council. which might otherwise be the position if it's necessary to trawl through all the files individually. And thirdly, as I've said, to notify the council, to inform the council as to where their procurement initiatives should be targeted. The sad reality is that almost no amount of money would get enough suitable accommodation, certainly for the London boroughs. It simply doesn't exist. Whether the Renters' Right Act will have an impact on that, we don't know. But at the moment, it's a dire situation as reflected in this report. So I'm foreshadowing a submission I'll make later, that Tower Hamlets will say that this database does not cause, is not causative of any substantial disadvantage to women. What it does, on the contrary, is because that's caused by an extraneous factor, namely the shortage of larger accommodation, as my friend Ms. Davis explained. What the database does is it mitigates the impact of that. Now, I'll develop that submission in due course when we look at the important point of causation, and also in relation to justification, because this is a sort of what the courts have described as safety valve. If there is a disparity, if the scales are tilting one side, it is Tower Hamlets' submission that the database rebalances it. Now, Lords, with those introductory remarks, leaving aside PSED, which I'll deal with discreetly, and subject, of course, to the court's preference, I propose to make the submissions, and I'll do so crisply, in the following order. Firstly, was there a PCP before the judge? And if so, what? That's grounds 1 and 2. Secondly, what is the comparator for the PCP? Thirdly, was there a particular disadvantage? Fourthly, if so, was that caused by the PCP? And fifthly, if so, was the judge right to hold that Tower Hamlets had justified that disadvantage? I'm sorry, justified the PCP, because of course it's the PCP that must be justified, not its discriminatory effect. If it's convenient for the court, I'll deal with the submissions in that order, and I can take them fairly shortly. It's the helpful way, if I may respectfully say so, that the case is being presented and the helpful interventions from the court. So the first question was there a PCP at all before the judge? And this is appeal grounds 1 and 2. Can I firstly invite the court to look at the way the appellant had pleaded her case. This is core bundle tab 17, page 215. The court will recall that the case was originally pleaded in the summer of 2023 after the provision of accommodation in accordance with the court's interim order. There was then a stay, and that stay was lifted by the appellant following the service of a notice to quit. And permission was granted to the appellant to amend her statement of case grounds. So at page 215, paragraph 22, we have the claim, the appellant's formulation of the PCP, and it's PCP in the singular. It was originally the transfer list, but it's amended to read operation of the allocation of temporary accommodation, which includes a transfer list. What is described in the...
Sorry, where are you reading from?
22, my lord, is at the top of the page. 215, the claimant avers that the defendant's operation of a system of allocation of temporary accommodation to homeless applicants, which includes a transfer list, is a PCP. So that's the pleaded case, one PCP, and it's the transfer list and the system, or the system incorporating the transfer list. What we don't, and that's described in my friend's skeleton, the appellant skeleton, as PCP1. What we don't find in the pleaded case
is it's a system with two component elements. One is the transfer list, and two people are on the transfer list.
Yes, yes. But it revolves around the transfer list. And the submission on that, this is on the point of the judge only dealt with it in part, is that you don't get on the database list, leaving aside those discretionary cases, the old one, you don't get on the database unless you're in unsuitable, or at least there's a case for a planned move. So it adds nothing to the description of the PCP to say, and the system, because that's necessarily part and parcel of the database. And indeed, that's how Shelter summarised it in their skeleton argument before the judge. So the submission is, there was no pleaded broader system that we now see manifesting itself as PCP2. That wasn't before the court. This case proceeded, and I'll take the court to the agreed issues. This case proceeded on the basis there was a single PCP, and that PCP focused, centred around the use of the database. So, respectfully, we say that the court was not seized of this much broader PCP. In any event, we say, how can you describe a PCP as a broad system of dealing with homeless applicants? This is a very complicated, detailed piece of legislation. There are 6 different accommodation powers or duty under Part 7. They range from a few weeks for the intentionally homeless with priority need, according to the Code of Guidance, to indefinite accommodation. The standard of suitability varies depending, there's a temporal quality to it, depending on how long it's going to be for. So, as Lord Justice Lewis held in the El Cundy case, resources, for example, may be relevant to the question of the suitability of accommodation in the short term, although it may not be relevant in the longer term.
I'm not quite sure that's what I said. I thought I said the opposite, but never mind. That's last week. This is discrimination, yes. Anyway, just
Lord, I'm sorry, I may have been reciting a submission I made after the Lordship's judgment and not the judgment itself. I apologise.
I mean, the 28 of the judgment, I understand there are 2 PCPs pleaded, and I understand that there's only one in the claim form, and I looked at the language of the claim form, and I've looked at the language in 28. But even if we're down to 1, you still have to address 28A, being placed in unsuitable accommodation, which is either statutorily unsuitable or deficient, and being placed in unsuitable accommodation with children. What's being said is, what they do is, if people are in unsuitable accommodation in the narrow sense of it doesn't meet the section 1932 duty, they're being put on a waiting list and they are staying there.
Yeah.
And it has said, by Mr. Davis, for example, that doing that, putting them on a waiting list and leaving them in unsuitable accommodation when you've agreed it's unsuitable, is a practice. And that practice has got to go through the hoops then to see if it's okay.
Well, my Lord, in our evidence, we accept in our evidence, if that were the correct analysis, then it would be wrong. Mr. Mohammed says that in his witness statement, but it's not. It's absolutely not the case. The whole point of the data list, of the database, is to bring into full focus those cases where there is unsuitable accommodation, and in order to do something about it. It's not, emphatically not, a waiting list.
No, I've got that point, but what is happening, the practice to reformulate it and have number 4 is you're in breach of your duty, you've accepted you aren't housing those people, what are you doing about it? you're putting them on a list and you're leaving them in unsuitable accommodation.
It's not as if they're putting them on the list and doing nothing about it. The evidence is that there's a daily routine. There's a department that deals with these. They make phone calls. The evidence is, for example, at the time, they were using a letting agency called Capital Letters, which was a consortium of London boroughs. And it's flagged up, interestingly, it's flagged up by the Children's Commissioner's report as an example of good practice here. And they were using that as one procedure to identify accommodation. So they weren't forgetting about people, quite the opposite. They were alerting themselves and making sure they didn't fall off the radar, which is why, respectfully, if an applicant finds himself in unsuitable accommodation, they are far better off on the database than off it. Can I just, my clients have asked me to make this clear, the court would accept this, of course. Tower Hamlets does not knowingly put its applicants into unsuitable accommodation. It will always satisfy itself that the accommodation is suitable. What often happens, and happened in this case, is for one reason or another the accommodation becomes unsuitable, family growth or disrepair or landlord wanting about whatever. So the way the appellant characterises the case, I understand how they do it, but it's fundamentally wrong and contrary to the evidence before the judge. So the first thing is the judge was only seized of this one PCP. Then the first decision that the judge made was that it wasn't properly understood a PCP at all, and that's his finding at para 45 of the judgment. And we say respectfully that that was right, or at least that was a decision that the judge was entitled to reach. Your Lordships have been referred to the very helpful analysis of Lady Justice Similar, she was, in the Ishola case, emphasising two things. Firstly, that Parliament, obviously, I think it came from an EU directive actually originally, but the legislator chose these words for a particular reason. It could have just said any act or any decision, it didn't. It chose these words. And secondly, that in the nexus, the common theme running through them is that a PCP has to be something that is capable of treating an individual in a particular way. It's got to be applied to someone. Under Section 19, there has to be an application, so it's got to be something that's applied. And the short submission, which found favour with the judge, which Tower Hamlets invites this court to consider and accept, is that it doesn't treat. All it does is it puts together existing information which would otherwise be held on a file. I think in our skeleton I may have referenced card index showing my age, but now it's an electronic file into a central system, a central tool which can be accessed in experienced hands very, very quickly and very, very efficiently. And that's only stage one of the process, because stage two of the process, as the evidence shows and I've explained, is once you get through down to the shortlisting, you then do the evaluation and have professional judgment exercise as whether it should be this household or that. If I can say, my instructions are that in reality very, very few cases ever come down to the tie break of waiting time. But quite rare, because inevitably officers with their experience will say that this second floor 2-bed unlifted flat is better for family C than A, B or D for these reasons, and make the decision. So it's only one part of a process which otherwise would have to be dealt with laboriously by going through file. That, we say respectfully, doesn't amount to a PCP. That's not something you can apply to someone. Even if you look at it in a broader sense and say, well, the system in which that includes, that's not a PCP. All it is the local authority doing its job. Local authorities, we put this in our skeleton, have to amass a considerable amount of information in a Part 7 case. We've put the, I won't take the courts in now because of the time, we've put the suitability regs in. A simple decision as to whether a fortnight's accommodation, in interim accommodation, involves considering space and layout, family composition, health needs, affordability, location. All these things have to be factored in if the local authority does its job. All this does is it speeds up that process efficiently and effectively. And that, we say respectfully, and when I'm reading it has to compare it with some of the other cases we've got in the bundle. So like TW, for example. TW was the Irish traveller case. The PCP there was Hillingdon's condition in its housing register that only applicants with a 10-year residence background in the borough can get on the register. Now that's a clear PCP because it's a disqualification. You have to meet it. And of course the finding there, in fact it was concession, was that had a disparate impact on Irish travellers and on refugees because vis-a-vis other groups applying, they were at a disadvantage. That's, we say, respectfully, a long, long way removed from what Tower Hamlets are doing here. So we say, first of all, and this, if the court accepts this part of the analysis, it ends there, so far as section 19 is concerned, because there's no PCP. If that's right, then we say there's no PCP, it's simply a tool that gives practical assistance to the defendant's housing officer, to the judge's justice. So that was entirely proper and a proper finding according to the evidence that was put before the court. Witness statements went in and there were detailed replies to requests for further information, but that was the basis on which the judicial review was fought. Can I then turn to the next question? So, Your Lordships have my submission that if there was no PCP, then that's the end of the section 19 point. The next question, we then get into the structure of section 19. We found, very respectfully, considerable help by reading the judgments of Lord Justice Lewis in the TW case, and in particular, Lady Hale in the Unison case, right at the end of that case. It's obiter, but we say, respectfully, it's a very helpful analysis of the way you approach section 19, and it's essentially a four-stage test. The first thing you have to do for section 19 is you have to identify the PCP under challenge. We've already had a discussion about that. First, identify the PCP. Secondly, you then identify two groups to whom that PCP is applied. The first group, Lord Justice Lewis calls the protected group, consists of those sharing the protected characteristic. So the second stage, you identify two groups. The first group is the protected group. Lady Hale calls that the subgroup. And then the second group you have to identify is the comparator group, which consists of everyone else to whom that PCP is applied, but who do not share that characteristic. Thirdly, you compare the two groups and ask whether the PCP puts those in the protected group at a particular disadvantage vis-a-vis those in the comparator group. And if so, then you get to the fourth stage. There is at that point prima facie discrimination, and the burden shifts to the defendant to justify. So those are the four stages. So it's pertinent to ask in this case, if we assume that the PCP was the database with the system which in which it operated, that's the PCP, then you have to ask, firstly, what is the protected group? That's easy. That's homeless women applicants on the database. That's the protected group.
Let me just get absolutely clear what you're saying, but the protected group is homeless.
Homeless applicants on the database in unsuitable accommodation and are women.
So women homeless applicants on the database in unsuitable accommodation.
In unsuitable accommodation, because they don't, for the present purposes, we have to accept there's some deficiency, if I can use that neutral word, in their accommodation. That's why they're on the database.
Oh no, that's why I asked, because deficiency is a different word. We spent a lot of time this morning, and I labour the point beyond belief. Suitable, I thought we'd now agreed, was accepted to be below the statutory standard. Deficiency means I would need another bedroom because I've got an extra son.
Yeah, I'm sorry if I'm confusing you, Roger. The reason I put it that way, what we're focusing on here, because things have moved on, we're focusing on the original database, not the later database. The original database admitted two types of Part 7.
Yes.
Those who were admittedly in unsuitable.
Those who were in statutorily agreed unsuitable accommodation, and those who wanted to manage change.
Yes, accommodation. Authority, and it's all explained in the witness statement, yes. Because that was devised at a time when.
So what are the pool? Just give it to me again so I can write it down. What do you say is the protected pool, the group who are being at issue here? Can you give it to me again?
It's effectively the women applicants on the database. They won't be
the current database or the old database? Are they different?
They won't be on the database unless they're owed the duty. And they won't be on the database unless there's an issue with their existing accommodation. So the protected group is those women on the database. So that's the protected group. Then we have to ask, well, what then is the comparative group? And our understanding of this case, again, I look at the way it's pleaded and the way it's been argued. There are two possible comparative groups here, as we understand it. The comparator is always going to be a man, a woman, accept that. But the question is, a man in what circle? Not just a man on the street, obviously, but because Section 23 says that the cases must not be materially different when you're looking at the two groups. You've got to read those groups through the lens of Section 23. So we said there are two possibilities here in terms of identifying the comparator group. The first is the male homeless applicant on the database. Now, the male homeless applicant will only get on the database, A, if he is owed some form of duty and probably have a priority need, or at least a prima facie priority need, which may or may not be. Children living with him may be severely disabled. And also in unsatisfactory accommodation of one type or another. So that's comparative group 1. And our headline submission is that if that's the comparative group, then there's no disparity between men and women. They're both subject to the same, on the appellant's case, detriment, on Tower Hamlets' case, benefit of being on it. So they are, as Lady Hale put it in the Unison case, all in the same boat. That's if the comparator group is defined as male homeless applicants on the database. In fact, and I'm very reluctant to get into statistics, bearing in mind what's happened. In fact, if that's right, then if there are more women on the database at any given time than men, and that's never been in contention on my case, then statistically, an offer of accommodation is more likely to go to a group of women than a group of men. So one could say that if there's any disparity, it's tilts towards men rather than women. I don't need to go that far for my case. The court has my submission. If, however, you say the comparator group is a much broader net and includes all homeless applicants, I mean, that itself creates a raft of difficulties, because you've got to, what this legislation is concerned with is comparing like with like, a level playing field.
Just to be clear, when you say all homeless applicants, all male homeless applicants?
Yes, I'm so sorry. I'm grateful to my Lord for the correction. The second group, I'm sorry, I get quite right, would have to be all male applicants dealt under the Part 7 umbrella.
Yes.
Against all female applicants dealt with under Part 7.
But the court has my first submission. That's going to be a very, very difficult comparison, because you're meant to try and compare like with like. And there's so many different circumstances that you will find. I'm not going to take time going through Part 7 and various provisions that are made, stages that the local authority have to go through. That's going to be a very, very difficult comparison to make. But even if you did, then you ask, what is it that's causing the disadvantage to women? My friend Miss Davis, by reference to her evidence, has already provided the answer to this. Not the database, it's extraneous factors. It's the shortage of larger accommodation. Typically, households require larger accommodation. That's in the shortest supply. That's what's causing the problem. It's nothing the database is doing. The database, as I submitted earlier, is mitigating the impact of that reality.
And just to be clear, earlier on you were explaining you were going to deal with PCP comparator, particularly disadvantage caused. Is this really a causation point?
Yes. Oh, absolutely, my Lord, yes. I'm so good. The key words in section 19 for this purpose are that it, namely the PCP, puts the at a disadvantage. There's this, and this, respectfully, despite the attractive presentation, is a gap in the appellant's case on this appeal. Causation is not addressed, yet the judge critically made a finding, what he, para 47, he described as the crucial point, is that in order to show that more women with children are affected by homelessness than men with children left in unsuitable temporary accommodation, it would be necessary to establish that the hypothetical male applicant, homeless applicant, is statistically more likely to receive an offer of permanent suitable accommodation as a result of being on the database. There's no evidence that that is the case. And I'm also not satisfied that there is a causal link between the use of the database and the particular disadvantage identified by the claimant. So, in a nutshell, even if the court accepts that this database and the system within which it operates is a PCP, and it does have this disparate impact, the reason, indeed, the pleaded reason on behalf of the appellant is because statistically more women are living in households, single parents, than men. They need larger accommodation, and there's a shortage of larger accommodation, and that's the root cause of the problem. It's nothing that the database is doing. So in the court, I didn't hear below, but I'm told by Miss Weech-Powell that the case for Tower Hamlets did not seriously challenge the statistics. The statistics take the national picture, and through the industry of Mr. Spratt and others, they then apply that to the to the database, the historic database and the snapshot and that, and they say, well, those proportions will probably, if you look at the 1 plus 1 or whatever households add those up, probably have the same pattern. That wasn't seriously disputed by time, nor could it be, because it's almost common knowledge. Inevitably, they're going to be more when Lord Justice Newey's already seen the point that the legislation is weighted in favour of women, always has been since 1977, and probably rightly so. So it's all those the factors there to take into account. So we say on a proper analysis, we do say the judge analysed it correctly. Even assuming everything else against them, this case falls down at the causal link point. So in those circumstances, a matter of construction of section 19, nothing shifts, no burden of proof shifts, because 1 through 6 says where the court believes there's discrimination, it's prima facie, then it shifts. We don't get that. There's no discrimination. There's no shift of the burden. But even if we're wrong about that, then we come to the issue of justification. We say, respectfully, that we say that this is to be found in the judgment. We say the legitimate aim is to ensure that such accommodation as may be procured is allocated to those in the greatest need, and quickly. That's the legitimate aim. And we say that the database is a proportionate means of achieving that aim for the reasons that I've already articulated. Now, in that helpful judgment of Lord Justice Lewison in the TW case, there's reference to an Ealing case, the judgment of Sir Terence Etterton, Master of the Rolls, I'll just give the reference, it's tab 18, paras 51 and 85 to 86. I'm not going to take the court's time, just, I don't feel under pressure of time, but if the court feels it would be helpful to look at it.
I wonder whether it might be helpful.
There's authorities bundle, tab 18. This, I've already explained, this was the case about the 10-year qualification condition to join the housing register. And at paragraph 51, which has somehow escaped the tram lining, I apologise for that, there's reference to a Crown on the application of H against Ealing London Borough Council. And then there's an extract on the following page, 432, at the top, from the judgment of the Master of the Rolls in that case. Begins 58, in the light of that acceptance, on the basis of those statistics and the concession made by Ealing, so on and so forth, there's prima facie indirect discrimination. So the Master of the Rolls had rejected Ealing's submissions there, but certain provisions in this was an allocation scheme case, meant that there was no prima facie discrimination. And then 59, in short, it is contradictory of Ealing's concede, on one hand, that for the purposes of section 19.2, the WHPS, that was the condition under challenge, is a PCP, and on the other hand, to seek to rely on Ealing's housing policy as a whole to rebut the discriminatory impact. What this highlights is that the matters on which Ealing relies, the so-called safety valves, on matters which properly are relevant to justification under section 19(2)(d). So the courts have, and there are other cases to that effect, the courts have identified this principle. If you've got disparity, see what there is that mitigates it. It's called a safety valve. But Lord Justice Lewison makes the very, very good point in TW, where what was relied on there is a general discretion that could be applied to everyone. He says, well, that if the scales are tilted, putting equal weight on either side still ends up with a tilted scale. What you want that to do is something that balances the scales. This is where it gets tricky under the Equality Act, respectfully, because you might think, your lordships wouldn't think, but someone might think, well, it's easy. Just adjust the database so that instead of having a wait time break at the end or something like that, just make sure that if there's a property that and two applicants are assessed for it, male and female, always give it to the female, always give it to the woman. That would be one way of telling it, but of course that would then be direct discrimination under section 13, so they can't do that. But the submission is that if you accept the appellant's case, that there are more women, and it's not seriously challenged, more women on the database than men, and you see the database, you accept the submission that the database is an advantage in the sense it keeps right on the radar, right full focus the needs. More women statistically are going to benefit from that than men. That's a safety valve. And it's a safety valve that actually, properly understood, favours women more than men. That, to use Lord Justice Lewison's analysis, that balances the scale. Now, the judge didn't deal with this at length or with subheadings, but the court will look to see whether in the substance of the judgment he has grappled with the relevant issues. I mean, the first point to note on the judgment, we're dealing with justification, is that the judge reminded himself, page 114 of the bundle, and this is paragraph 14 under the subheading indirect discrimination, reminded himself of Lord Reed, JSC's test in Bank Mellick. So the judge had directed himself as to the test for proportionality. The judge expressed his findings succinctly on the matter in para 48. That is to be read, like so much of this case, the judge found the assistance of counsel considerable, not least counsel who sits behind me. That refers back to paragraphs 39 and 40, and 39, where Ms. Screech-Powell submits that the defendant's evidence addresses the justification of maintaining the database. It maintains a database to equip it with a mechanism to manage applicants in need of a move and available stock in the context of a severe shortage of accommodation well known to this court, and so on and so forth. And we say, looking at this respectfully in a common sense way, what the judge is saying, well, that's the problem. The problem is the shortage. That's the legitimate aim, or how best to deal with that shortage. And this is an effective way of addressing that. So if one looks at the substance of the judgment, which, if I may respectfully say so, is commendable by its brevity. But it's brevity, but it's clear, because the judge has explained the arguments that were presented to him, clear what was in the judge's mind in that situation. That the judge has quite properly addressed the issue of justification, perhaps not in the formulaic way that some people might expect, but in substance. It cannot be said respectfully that it's wrong. So that deals with justification. And because my friend very kindly indicated this morning that round 7, I think, isn't being pursued, it leaves me to deal with just two matters. Firstly, the PSED, and what is left over of the academic question that Lord Justice Arnold left over. I can deal with that very shortly. And I'll deal with that in the end, if I may, in connection with relief, what this court should do if it allows the appeal to involved.
As I understood it, the suggestion that the appeal is academic only applies to ground 6. The PSED now, there's no suggestion you've accepted that it's not academic in relation to grounds 1 and 5, because if she wins on indirect discrimination, she'll be entitled to compensation, for example.
Yeah.
And she's entitled to bring that by way of judicial review. Whether it's sensible is another question. So I thought you'd accepted in your later skeleton that it's not academic, save in relation now to PSED.
That's absolutely right. Can I just qualify? There were two reasons advanced. Your Lordship may see that Lord Justice Arnold required submissions on this, submission stage. There were two reasons given on behalf of the appellant why the discrimination grounds were not academic. The first is that there's an extant claim for damages. That's all that's left in these proceedings. And the second is that as a duty is still owed and being performed, and has been for 2 years, it's possible that the appellant will fall out of that accommodation and come back into the system.
That's not being pursued now.
We say that's a future hypothetical with which this court doesn't normally deal. So we made our concession on the limited basis that there would be a res judicata on the basis of this judgment on the damages claim.
Yes.
So the only value of this claim, respectfully we say, is a damages claim that will go...
Grounds 1 to 5.
Yeah. On the PSED, I'm not going to take much time for the court to do with that. If I may, I'll roll it up with what we say about relief, because the question, the court is being asked to do a number of things, remit it, or possibly to take on itself the powers of the court below and grant declaratory relief. The academic nature of the case would have an impact on that. Indeed, whether it's remitted at all. It is, apart from the damages claim, which is self-standing, it wouldn't make any difference.
The first question we've got to decide is whether the judge was wrong to say there was no breach of section 149. If the judge was not wrong, that's the end of that. If he was wrong, and if in his analysis, I suppose there are two questions. One, was there a breach and can we decide that? Or two, is it now academic? It's not necessary for us or indeed anyone else to
No, indeed. No. I mean, we do say that the PSED is an academic issue, and on that reason alone the court shouldn't deal with it. But can I just make my submissions on the PSED? I mean, the headline submission is we've all come a long way since Bracking. That was 11 years ago. And if I may respectfully say so, decision makers are now far more acute of the discipline that section 149 imposes. It's become, quite rightly, a second nature. The jurisprudence has developed accordingly. We've invited the court's attention to what Lord Chief Justice says in the end violence case. If we can have a quick look at that, please. That's at tab 21. Two reasons for going here. Tab 21, and it's para 86, which is internal page 535. Tab 21, internal paragraph number 86, on page 535. This case concerned a code of Crown prosecutors. Didn't think the facts were. This is self-standing dictum. Section 149 of the 2010 Act applies to a public authority when it exercises its functions. It requires a public authority to give the equality needs which are listed in Section 149 the regard which is due in the particular context. It does not dictate a particular result It does not require an elaborate structure of secondary decision-making every time a public authority makes any decision which it might engage the listed equality needs, however remotely. The court is not concerned with formulaic box ticking, but with the question of whether in substance the public authorities comply with section 149. Public authority comply with 149 even if the decision maker does not refer to it. In fact, I think Lord Newberger, President of the Supreme Court, went further in her text, said there can be unconscious compliance if you do the right thing. Can I just, the second reason for going there, can we just look back paragraph 85, please? Because that's a reference to the case of Powell and Decorum, which is the case of Lord Justice Lewis was thinking of earlier, in which Lord Justice McComb, who was in Bracking, said that dictum that my friend took the court to was not to be read as if it was statutes. That was the point. But the law was ahead of me on that, of course. And the other case, which we say is helpful, which is a case called McMahon, which I think is in the supplementary bundle. We didn't put this in our skeleton. We put a whole raft of cases. The value of McMahon is that Lord Justice Lewison does a trawl through them all, and very, very helpful analysis, respectfully. Can I just, it's another housing case. Can I just, it's just one paragraph I would pick up to make good a submission, and it's paragraph 67. And it's a principle that's been developed under PSED case law about overlap. His Lordship said the greater the overlap between the particular statutory duty under consideration and the PSED, the more likely it is that in performing the statutory duty, the authority will also have to comply with the PSED, even if not expressly mentioned. Now, it's helpful, we say, to compare and contrast two cases that represent the opposite ends of the spectrum here. One is the Peretti case, which the court has been referred to, Peretti. And I can just explain why it's relevant. Peretti was a decision on intentional homelessness, where the applicant had mental health issues. Now, there was no overlap between the question of whether somebody's intentionally, or no obvious overlap, which is simply a question of fact and judgment as to whether a person's intentionally homeless and mental illness. But an appreciation of the mental illness might have informed the decision better on the question of whether the act was intentional. So there was no overlap there. That was a case. Peretti, I should say, was the test case on the application of the PSED to functions decision-making under Part 7. So that was a case where the PSED added something. MacDonald, the case that Lord Justice Lewison refers to, it's not enough under a Supreme Court case, concerned a nighttime care provision. A lady who had suffered a stroke and had to visit the bathroom frequently at night. And there was a change in her care package from somebody sitting in her room to the use of continence products. And there was total overlap. The whole decision was needs-based, disability-based. The whole mindset of the decision-maker was on the disability of the applicant. So what could the PSED add to that?
Well, if that's a question, there's the housing need, what does she need, and so on. Then there's the question of, given what's happened, given that there's a long-standing inability to meet the duty, is this working harder on women with children? Shouldn't we be pulling out a few more stops?
Yes, but
and get accommodation for women with children?
Yeah.
If they just think it's a housing thing and think, oh, don't worry, we'll take a risk. We get Mr. Rutley, one imam, he'll run the next one. That's different from, should we be treating women like this, mothers with children?
Well, what we're saying is because it's the very essence of this database that you're looking at need, not looking at other factors, you're looking at need, housing need, then you are focused. It's difficult, we say, it's difficult to see, apart from just for formulaic reasons, what consideration of the PSED would add to it. Now, I can't take the court to any impact assessment on this.
Just instinctive, it's just inevitable. They were dealing with the nature of the circumstances. A woman with a child who needed accommodation, and they had to assess the needs of the child. And
yes,
and they already assessed that. The problem was they weren't complying with them.
And I do rely on the fact that it's only one part of the process. As I've submitted, the database filters, and then you get officer evaluation. So it's at full focus, and there was no. I really don't want to argue this case on pleaded points. It's too important for that. But it is significant that there was no substantive case pleaded on the PSED. Just there was a breach of the PSED. And Ms. Screech-Powell did advance submissions before the judge, which again he accepted. Deals with PSED paragraph 50, but that harks back to paragraph 42. So Ms. Screech-Powell submitted that there are a number of features of this which in fact favoured women. For example, a single-parent household with children considered for more spacious properties, seeking to assist suitably housed single parents with young children into one-bedroom unit studio flats being considered then for a move when the child reaches 12. The appellant here was a beneficiary of that, absorbing a rental increase of approximately 33% when the claimant couldn't remain in her current accommodation, devising a system of holding information and fairly equally identifying the essential needs of an applicant. So, more generally, proactively taking steps to address the housing crisis, leading the way with new build schemes. So, it wasn't as if we came to court empty-handed. It was saying, look, there are these initiatives. They cannot, I emphasise the point, they can't write into the scheme, oh, we give preference to women. That would be unlawful. They can't do that. They protect the rights of women by putting them on the database, by flagging up their cases, as with men, but proportionally more women would be beneficiaries, and getting them successfully into other accommodation in the midst of that awful situation that we looked at the outset of my submissions, starkly described by shelters. 79% of councils struggling to comply with their statutory duties. So we say respectfully, this is a good thing. The database is a very good thing. This is an important case. My clients are here. The architect of this scheme is here. Other local authorities are looking on. I've taken, I'm not going to take time to it now, but in our skeleton we've flagged up passages in the Code of Guidance which encourage local authorities to develop tools to enable them better to assess housing need and things like that. This is a pioneering way forward to better understand, define and address housing needs. It does not respectfully discriminate. It certainly doesn't discriminate unlawfully. On the contrary, it helps applicants. So in our very respectful submission, the judge, who gave very careful consideration, that comes through in the judgment, to the claim, felt that the case hadn't been made out at each stage. And we say that the appellant has failed to show that that was wrong. May I just have a moment, my lord? I'm just, whether the court requires any further assistance on the question of remittal or relief.
Is there anything else you want to tell us about remittal?
Yes, I think on the appellant's notice, just go to that. So I'm looking at tab 1 of the core bundle, page 8,
Yes.
section 9 of the appellant notice. Obviously, if the court allows the appeal, then we couldn't object to a transfer of the question of damages to the county court.
Well, hold on. If we don't know about justification, then you would be, wouldn't you? I mean, if we can't decide justification, the fact that you've got 1, 2, and 3, you've lost on 1, 2, and 3 of the statute, PCP at a disadvantage, puts the appellant at a disadvantage, somebody's still got to decide justification.
If we lose on the grounds up to that point.
You can't assess damages until you've done proportionality, can you?
No, sorry. If the appellant wins on the appeal,
including justification.
I'm so sorry. Yes. Then it would fall to be remitted to the court, the county court, to deal with damages.
Well, strictly we deal with it unless there's been an order for a split trial. There have been a number of cases where the court itself have dealt with damages. We've got no evidence about damages here. We could simply deal with it.
Well, can I say respectfully that cost proportionality is a big worry for the local authority in this case, bearing in mind the academic nature of the appeal itself. So can I respectfully suggest that any submissions on this line are made in the light of the court's judgment? With that, depending on what the court does, then submissions can be made in the terms of relief. I think Lordship had my headline submissions that we are dealing with a case where the appellant has been successfully rehoused for over 2 years. Nearly 2 years.
What we're dealing is whether that 2-year period she was treated in a way that was not just unlawful under the Housing Act, but discriminatory under the Equality Act.
Yes, I understand.
So the fact that she's now not being treated unlawfully any longer doesn't really help, does it?
No, that's what I said.
We stopped beating her, but what happened before we stopped is the question.
Well, those are my submissions.
Thanks very much. Ms. Meyer.
Thank you. Just a very few points in reply. I may have misheard this, but just in case, I think my Lord Justice Lewis observed that the appellant only relied on a disparity in relation to single-parent women and single-parent men. Perhaps I misheard.
No, my understanding was that you relied on both.
Yes.
It was Miss Davis who said you relied on one, and that wasn't my understanding of your case.
I'm great.
You were single women with children and women generally. I've written it down.
I'm grateful. I'm obviously misheard. And just, if I may, to bottom that out, if I can invite you to look at page 1, I don't need to do it now, but 146 of the skeleton argument below, which reflects the statistics, as I think Ms Davis has said. Yeah. But you've seen that, and so just to flag that out, paragraph 74 and 75, and picking up on the statistics by Ms Davis. With that clarification that wasn't required, just a few short points, if I may. As to PCP, Mr Rutledge referred you to TW, that's the Irish Travellers Residence Requirement. Irish travellers, because they travel, are less likely to be able to comply with the requirement to be in one place for a long period of time. Mr Rutledge says that's the sort of thing we're looking at. We're not looking at that with respect. That would have been the sort of thing we would be looking at under the Sex Discrimination Act prior to the amendments made in consequence of the amended Equal Treatment Directive, which I know my Lord Justice Lewis is familiar with, and there was amendments made to the Act to ensure compliance with EU law and a much more flexible concept of PCPs. So we're decidedly not limited to that. Not only are we decidedly not, that was apparent from the legislative change made to give effect to EU law and then introduced by Parliament through primary legislation in the Equality Act. So that's my point on that. Second point is in relation to causation. What causes the disadvantage? We say what causes the disadvantage is the putting of a person on the list and the arrangements made, however one defines it. And Mr. Rutledge says, well, no, what causes the disadvantage is all sorts of extraneous things, like the sorts of matters that Ms. Davis picked up on, social reality, poverty, and so on, that women experience.
Well, I think he's more narrow here. The reason why they don't get housing is because they haven't got any. It's the simple shortage of accommodation, particularly large accommodation. He said, that's what we're focusing on here. That's why suitable housing isn't provided. As to why it's more women than men need housing, that's because they are in greater social need and they tend to be carers of children, and you've got to put the children somewhere. But it's the extraneous cause, he says, is the shortage of accommodation in London.
Yes, and just if I can look at that through the prism of ESOP that we were looking at earlier on. Of course, in ESOP, it wasn't known why disproportionate numbers of BME candidates failed. There'd been research undertaken, it couldn't be identified. One could posit a number of possibilities speculatively. Language requirements, for example, the extent to which one's first language is English, and so on. We don't know, we didn't know. But the fact that there may have been explanations for that, unknown or known as here, didn't mean that that was the causation, that there wasn't causation. What caused the disadvantage was the application of the requirement to undertake a test.
But the case here, just sorry to cut you short, is that the problem is women in unsuitable accommodation, that is, accommodation that falls below the statutory test. And the reason for that, assume it's known for the moment, is the reason why they're breaking the law, and it's what was in Imam and Al-Kundi, is there aren't enough houses.
And there may have been a reason why in ESOP, but that was nothing to the point at the disadvantage stage. So when looking at whether the PCP is causing the disadvantage, we say it's causing the disadvantage, requirement to go on, in summary, transfer list, because we can see that there is disparate impact as a consequence of that. More women are adversely affected. There is a social and contextual reason for that, but at that stage, we're looking at, does the PCP cause the disadvantage, greater prevalence of unsuitability in housing?
That's what I'm having trouble with. The argument against you is the PCP doesn't, because going on the list or not going on the list makes no difference. The fundamental problem is eroded duty and it's not being met, because with the best will in the world, they say there isn't a house.
Well,
that's the problem. It's not that going on the database. You can tell it's not going on the database. They say because if you're off it or on it, they say they haven't got a house.
Well, what we know is that there are disproportionate numbers of women who go on the database and remain in unsuitable housing relative to men, whether that's treated as lone parents or as men and women together.
Yeah.
So there are disproportionate numbers on the transfer list and in unsuitable accommodation. And that is a disproportionality, not just a numerical analysis. That's what Ms. Davis took you to before lunch. So if there is a causal link between the PCP, go on there, and the disadvantage, you are more likely to be in unsuitable accommodation than if you're off the list, then the PCP is causing that disadvantage. There may be contextual reasons for it, and indeed they may go to justification. And I think everybody accepts that the context, those contextual or extraneous matters that have been alluded to, will be relevant to justification. But that analysis hasn't happened. We haven't got to justification. So we make the point that causation at this stage is not material.
Can I just test it a bit more? I mean, a version of the PCP at least is operating a system including the list. So I might think, well, let's ask ourselves whether the position would be any different if there weren't a list. And there isn't really any reason to suppose it would have been any different, is there?
Well, we don't know. We don't know whether that you would have had better civil servants if they didn't have to take a test in ESOP. What we know is they were required, and there was a disadvantage. Here, what we know is, and I think this was explored, in fact, by your lordship, that what we don't know what could happen. If there is a causal link, as we say, there may be, and the disadvantage is identified, sex is known, because they comply with their PSED, the sex disadvantage is known, it may be, they say, we've got to do something. We've got to try a bit harder. If 5 of our reviewing officers are off sick, we're going to have to spend more money getting them from an agency. I don't know if that's the case. But
the lack of housing officers, they've suggested that. It's a straightforward, and we had this for days in Kundi and Imam. They should be providing accommodation. The law is clear. They tried to say they didn't have duties and so on, and they lost. But now they're saying they haven't got the houses.
well,
And
sorry.
it's not like ESOP. Why are people failing an exam? That's difficult. It could be cultural, it could be linguistic. If you come from Wales, you don't necessarily read the same books as if you come from London. But this is a different thing. They need accommodation with 1 bedroom or 2 bedrooms. Sometimes they need disabled accommodation. And you can walk around the borough, and it isn't there. They say that's their case.
Well, it's bemusing as to why there is that disproportionality. There is, if it be just that there isn't housing, and I don't say for a moment that isn't a relevant context, and most especially for justification, but what we are concerned with is the fact that proportionately more women who go on the list find themselves in unsuitable accommodation relative to the men.
Can I just unpack that a little, or try to clarify it a little? Now I've understood the figures a bit better. Insofar as people are on the list, as far as I can see, there's absolutely no indication that men fare better than women. What Miss Davis was pointing out, as I understand it, was essentially that if you take the overall pool of people owed duties, you find that a higher percentage of women end up on the list than there are in the overall pool. And in real terms, that's down to what's happened to lone females and lone males.
But it's also, it goes further than that, because it also is that they find themselves in unsuitable accommodation.
They do, but they are no more likely than men on the list to find themselves in unsuitable accommodation. If you work through the statistics, once you're on the list, you are no more likely to end up in unsuitable accommodation if you're a man than if you're a woman. Ms Davis's point, essentially, as I understand it, was, look, you're more likely to be on the list if you're a woman, as compared with the overall pool. And I think the explanation for that must be that you're knocking out most lone females, most lone males. Now, if that's the sort of overall truth of the thing, why is it going to be any different if you take away the list?
Well, we say being on the list also has a disproportionate impact insofar as suitable and unsuitable accommodation is concerned. So not just on the lift.
Once you're on the list, you're just as likely to end up in unsuitable accommodation whether you're a man or a woman. But the point is you're more likely to be on the list if you're a woman as compared with the overall pool. That's where the change happens from the overall pool to being on the list. And it's really down to lone females and lone males.
In my submission, it's not just that, because as we've said, and as Ms Davis has said, if one looks at it's a suitability issue as well, isn't it?
I mean, just take an example, and of course you can take different ones, but if you compare the figures for single mothers and single fathers, then as I understand it, well, actually, if you take just those figures, you don't find any difference at all. You go from the men account for 10.5% in the total, Info 1 total, they account for 10.4%, unsuitable 10.3%, Info 2 total 10.25%, unsuitable 10.4%. There's just no change.
Well, if I can ask you to look at page 146, which I skimmed over because I had misunderstood, misidentified that it was Ms Davis and not my Lord Justice Lewis.
Ms Davis did stress the unsuitability column, but the unsuitability column correlates with the being on the database in the first place column. Where there isn't a complete correlation is when you go from the total pool to being on the database. And I seem to have mislaid what this. Yes, I've got it.
Oh, excuse me. I think the point's already been made that we're looking at the total in. Mr. Spratt's urging me to make this point. I think I've made it, but I just want to, in case I haven't and I get told off. The second column, total in TA, and then unsuitable. But I think we've
yes, and the point I'm making is actually the jump is from total in TA to total in the list, because once you work through from the total in the list, the percentages don't really change.
Well, if one looks at it through a different lens, which I think Ms Davis was, and picking it up at paragraph 74 in the skeleton, and this is a point I think Mr Spratt was making to you before lunch. So the gender neutrality, I completely agree, my lord, is not a helpful way of describing it, but what it means is we don't know whether there are men or women in there, and they're likely to be probably evenly spread, so couples and so on. So as such, if we assume neutrality or non-sex specific couples and other households, if we assume them, as such, if we assume gender neutrality in couples and other households, that is, there's no difference so far as men and women are concerned. Service users to whom the defendant provides temporary accommodation are 65 and 30 men. If the particular disadvantage to C is being provided with unsuitable accommodation, then we go info 1 72.79. So that is a big leap as compared to as compared to the early one. Temporary accommodation 65.
I dare say the statistics right, I don't know, but if you look at it, it's all down to losing the lone females and lone males.
Well, that may be an explanation. That's not been explored. But it's not been explored, and the statistics have been accepted as they are, and indeed again in submissions today. It's not said you shouldn't look at them like that.
No.
It's not said they're wrong or they're giving you a false impression. Again, in oral submissions today, notwithstanding the argument, the discussion this morning, Mr. Rutledge still says on behalf of Tower Hamlets, we don't dispute any of this. I mean, he has other. I'm not suggesting that that's the end of it. He has other arguments.
Disputed. The numbers 1129 and the purport of the not disputed is what you get from them. I must say, I'm still having immense trouble in working out just 65.95. The service user to whom D provides temporary accommodation generally. Well, I'm assuming that's what we call all people given Part 7 accommodation, and it's the total in TA. And I'll do it again, but I just can't find a combination of figures that leads to 65.95 in paragraph 74 and 72.79% in paragraph 75. But I'll go away and do it again.
I suspect I can work that one out.
Oh, right. It's probably my maths, and I may have missed a column, but...
And if I may just, to be absolutely clear, we do adopt and endorse the analysis by Ms Davis, and the analysis from Ms Davis, of course, was derived from the data we provided, the analysis we provided, and perhaps that sets it out more clearly. I think it does.
I can get to the figures,
and
how you get it, if you want, anybody wants to know. If you take the total in TA column, and you take 34.2% as single mothers, plus 12.5% as lone females, half of other, and half of 2 or more adults,
Yeah.
then you get to 65.95%.
Right, that will explain, because I thought we discussed leaving them in or putting them all in, but in fact you're taking one half of them. Okay.
Yes, yes.
So I will be able to, even with my limited mathematical skills, be able to. I just divide the couples in two, and I divide the loans in two.
Yes, yeah.
And the others in two, sorry.
Yeah. I probably can't say any more than the statistics. We do rely on Ms Davis's analysis, helpfully in her skeleton, mindful that that comes from ours. That's not a criticism, but I don't want you lordships to think we've just made it up.
I mean, leaving aside all the detail, your punchline, as I understand it, is, look, when you compare the percentage of women in the total who are getting, who are owed duties by the local authority with those who end up on the list, the percentage of women goes up.
Yeah, and to be clear as well, excuse me.
But that's the same thing. Since the numbers correlate across whether it's suitable or unsuitable, and I really do think that is the case, then you will find that it doesn't really matter. It's the same point. The numbers go up as a percentage because the lone people drop out.
And the proportion of women in unsuitable accommodation goes up.
Yes, because it correlates with those on the list.
Just if I can say one thing in relation to the statistics on a different point, of course, the London Borough of Tower Hamlets didn't know all this because they don't collect the data, they don't analyse by sex, and that is important for the public sector equality duty. I just have to ask Mr. Spratt because otherwise he's going to tell me.
Yes.
Do you want to say? No, that's fine. Okay, I'm grateful he's stopped nudging me. There's something to be said for the Lady Chief Justice's direction. I wish I'd thought of that before I got on my feet this morning. My lords, those are my points in reply, unless there's anything I can assist you with further.
I don't detect anything else, in which case you will be staggered to know that we are not going to give judgment today. You will receive draft judgments in due course for you to comment on our English and typing, but not so as to re-argue the case. We'd be grateful also if at that stage you would seek to agree an order dealing with consequential matters. If there are points in which you can't agree, can we please have brief written submissions, and we would expect to settle points in the order that we make. I ought finally to remind you of what you will already be very well aware of, which is the importance attached to the embargo. We have had a contact list, I think, from you. If you think of anybody else who needs to see the judgment in draft, obviously you need to come back to us to get that approved. But thank you very much for your very helpful.